Tonight, two state Supreme Courts with two very different outcomes over whether or not Donald Trump is disqualified from seeking the presidency for a third time under the 14th Amendment's insurrectionist ban. In Michigan, justices there rejecting an effort to boot Trump from the primary ballot on procedural grounds, though appearing to leave the door open for renewing these efforts playing out in many states in the general election. Meanwhile, the Republican Party in Colorado has just asked the U.S. Supreme Court to overturn that state's Supreme Court's unprecedented decision to kick Trump off the primary ballot, with the ruling arguing that he not only incited an insurrection, but participated in it. Trump responding to what happened in Michigan and what could happen soon in Colorado earlier today.
It's very bad for Colorado, very, very bad for Colorado. But we just had the big win in Michigan today, and that was a good one. And we have 33 wins. And this isn't a loss because we'll have to see what happens. This is not a final determination, as you know.
Not totally clear which 33 wins he's referencing there, but what we do know is that these efforts to disqualify Trump from the ballot have been rejected so far in at least 4 states. Tonight, decisions are still pending in Oregon and in Maine. Whatever these states decide, it does appear increasingly clear that all of this could ultimately be up to the nation's highest court to settle this matter. Here tonight, CNN senior legal analyst and former federal prosecutor Ellie Hoenig. Also with us, conservative lawyer and contributor for The Atlantic, George Conway. Ellie, let me start with you because this Michigan ruling is obviously a win for Trump, but can you just kind of walk us through how the Michigan Supreme Court comes to this decision when we saw a very different decision, still a 4-3 one from the Colorado Supreme Court just last week?
Okay, so first of all, this is chaos, right? I mean, we see different states seemingly every few days coming to different resolutions based on different criteria. But if I had to sort of unify what happened here, how do we get one resolution in Michigan, the other in Colorado? The answer is that in Colorado, there is this pre-existing legal procedure that you can use to challenge someone's qualifications for the ballot. So they had this mini hearing, took 5 days back in October, November, and the Colorado Supreme Court said, good enough. In Michigan, there is no comparable proceeding. So the Michigan Supreme Court today essentially said, we don't have a way to do this in this state. My general criticism, complaint about this 14th Amendment effort is I don't believe it's up to the states at all. I think the 14th Amendment is clear on its face that it's up to Congress to tell us how this works, and they've not delegated that to the state.
So for you, there's no gray area?
No, I think this is no go. I think the only way to do it is based on what Congress has done. The amendment itself, Section 5, says Congress is to tell us how this works. The only thing Congress has done is they passed a criminal law many years ago saying it's a crime to commit insurrection. If you do, you're disqualified. That's not great. If people have a complaint with that, complain to Congress because they've failed to act.
So I'm glad you said that because, George Conway, you were initially skeptical of this entire premise of Section 3 of the 14th Amendment barring someone, former President Donald Trump, from ever serving again, from qualifying to run for president again. But you have changed your mind on that following the ruling from the Colorado Supreme Court. Why?
Yeah, I approach this whole issue with trepidation because it is a big deal to throw a former president off the ballot. But I was convinced very much by the original law review article written by the conservative law professors. I said, wow, this is a much stronger argument than I thought. But I still felt that courts were going to try to look for a way out and that somehow, some genius legal lawyer or law professor would come out with a response. And when I saw the Colorado case, I didn't see one. I didn't see a federal argument against what the Colorado Supreme Court did. And all the arguments that I have seen against disqualification are bogus, like the one with, my friend Ellie just mentioned. He suggests that the only way that Section 3 of the 14th Amendment could be enforced is through an act of Congress. That's just not true. There's nothing in Section 3 that says that. There's nothing that says that in the other provisions of the 14th Amendment. And if it were true, that would mean that if Congress repealed tomorrow all of the civil rights acts that were enacted from the time of the Civil War through the 60s to the present, that would mean under Section 1, that Section 1, which prohibits race discrimination, that would mean that the states could immediately start resegregating their schools and there would be no way to enforce it. That's just not the law. And there's nothing in the 14th Amendment that says that Section 3 is any different than Section 1 in that score. So that argument just goes out the door. all the other arguments that I've seen that have been raised, like the argument that the president is not an officer, is just, that one is silly because the Constitution refers to the presidency as an office dozens of times. So, I mean, really, the arguments are pathetically weak, and unless somebody comes up with something better, the Supreme Court's going to have a very difficult time avoiding the consequence of the plain language of the 14th Amendment.
Ellie?
I agree with original George here, where he started off. There is language on this specifically in the 14th Amendment. Everyone's talking about Section 3, which is very important. It says if an officer engages in insurrection or gives comfort to enemies of the country, he's disqualified. Great. But Section 5 is two sections ahead that says Congress shall have the power to pass legislation to enact this amendment. So has Congress done that? No, it doesn't say Congress shall have the power, or states can if they feel like it.
That's nonsense. Ellie, that's just complete nonsense.
It's the language of Section 5. I think we have Section 5. We'll call it up. What's your response to that? Section 5 is clear. It says Congress has the power.
What you just said, it does have the power, but it does not say, what it does not say is that the amendment is not self-executing. And that's the point I was making with Section 1, Ellie. What it means is that if Section 3 says somebody who's engaged in an insurrection is not eligible if they've already taken an oath, then that's what it means. You don't need Congress to tell you to follow the Constitution, no more than you need Congress to tell you to follow the Section 1's prohibition in the 14th Amendment that says that you can't put black kids in a different school.
I'm not following
it's
that
just not
analogy
that hard.
whatsoever.
I don't know what you're talking about.
Congress shall have the power. This self-executing point.
Congress says
that
provision, Ellie, you know better. You've read the provision. That provision applies to Section 1 as well. Your logic would mean that that states could engage in race discrimination tomorrow if all the civil rights statutes were gone. It's just nonsense, Ellie.
Not at all. That's not what it means. It says Congress shall have the power. You're trying to add in states.
It's nonsense, Ellie. It's not an argument. It's not a serious argument, Ellie. I'm sorry. It's not a serious argument.
I mean, you're speaking in conclusory terms. You're not addressing the actual issue. Let me
I'm
make this point about
You're
the
the one speaking in
self-executing point.
conclusory terms. Elliot, I made a complete argument that Section 3 is parallel to Section 1. That's what we do as lawyers. We don't say that a provision that's like Section 5 that says that Congress has the power, that does not mean that a provision of the Constitution is not enforceable unless Congress says so. That's nonsense. Okay. If the framers of the 14th Amendment had meant to say that, they could have said that in words of one syllable. Instead, they said in Section 3 that somebody who engages in an oath to the Constitution, to support the Constitution, then engages in insurrection, which isn't really a hard requirement for somebody to meet, not engaging in insurrection, they're barred. And it says that without regard. It doesn't say unless Congress does something in Section 5. It doesn't say that. And I'm a conservative. I was a member of the Federal Society. This is how we read plain text. We don't make stuff up just because we don't like the result.
This is not textualism. This is pretzel logic. I agree with you. Let's take it as a given that Donald Trump... George, you have to let me talk at some point. George, come on, you're filibustering.
Okay.
Let's let Ellie make his point, and then I got a question for you, George.
Let's take it as a given that Donald Trump engaged in insurrection. The amendment itself is clear. You want to talk text? Section 5 is clear as can be. Congress has the power. What you're trying to do is read into it, and so do the states. Let me also make this...
You're misreading Section 5. The text says Congress has the power.
We'll put it up again.
It doesn't say that... Okay, it says Congress has the power. It doesn't say that Section 3 doesn't stand alone. It just doesn't.
George,
you're just,
you have to let me. You have to give me a second here, George.
Okay,
the self-executing point is one you keep going.
Ellie, you're just not making any sense.
Okay,
George, listen.
Can we?
I'm sorry.
For the viewers at home who are wondering, I mean, at the heart of this. And I think this is important, George, because what you were writing, what I referenced earlier, is that you formerly were skeptical of the idea that this is something that could bar Trump from the ballot. But what about the argument here that we've heard even from people who, and I should note that you are certainly not a fan of Donald Trump's, but what about the argument that for a court to make this decision, not the voters, that it's undemocratic, that they should make the decision of who's on the ballot instead of just simply the voters deciding who should be on the ballot for something of this matter?
That doesn't work either, because the provision we're talking about, Section 14A3, was approved by Congress and by the states. And there are other provisions in the Constitution, like the requirement that the president be 35 years old, that he be a natural born or she be a natural born citizen. Those too restrict the ability of people to vote for whoever they want. And the democratic way to overturn those requirements, including the requirement, which is, again, as I say, is a really easy one, don't engage in an insurrection, don't try to overthrow the government. The way to overturn that requirement or modify it is the democratic process of proposing and the Congress adopting and then the state legislatures approving another constitutional amendment that undoes Section 3 of the 14th Amendment, at least as far as it affects Trump. I don't know. Well, so that's the democratic process that should be involved here. If they have a problem with what the Constitution says, that's the way to fix it.
Well, Ellie, I'm curious. I mean, this does seem headed for the Supreme Court. The Republican Party in Colorado appealing this. Trump's team is telling us they're expected to appeal it basically any minute now. How does the Supreme Court hear an argument like what George Conway is making there?
Yeah, so I think the Supreme Court's going to reverse Colorado. So a couple points here. The target of the 14th Amendment activists keeps on moving. The original theory was, as George said, self-executing, meaning secretaries of state could do this. Every secretary of state to consider this has rejected it, including Jocelyn Benson, prominent Democrat in Michigan. Brad Raffensperger, guy knows a thing or two about insurrection. He rejected it. We're waiting to hear from Maine. They're 0 for everybody so far. In the courts have rejected this not because they found Donald Trump did not engage in insurrection. The courts have rejected this on due process grounds. And that's why Colorado today is 1 out of about 18 or so lawsuits that's gotten any traction. You can do the math on that. The batting average, George, is 0.52. And I think it's about to be knocked down to 0.00 when the Supreme Court reverses this.
George, final word?
But that may very well be the case. But the problem is, courts have to apply the law as it's written, not as they want it to be, and they can't avoid difficult decisions. It's like if you become a judge, you have to apply the law as written. It's like if you become an HR director at a company, you got to fire people. And that's what's going on here is courts are looking for a way out. But right now, there is no good, sensible legal way out.
Ellie Hoenig, George Conway. I love a robust discussion to kick off our 9 p.m. hour. Thank you both for that. Up ahead, we'll see if we continue this. The Iowa caucus